Good morning. This is Melanie Daly here with the Daily Grind, here to discuss another workers' compensation issue over a hot cup of coffee. Today, I'm going to just briefly touch on Section 44, which is a complicated part of the workers' compensation law that a lot of people are not familiar with, even law judges and claimants attorneys. So essentially, this occurs when there is an occupational disease that has been established and there is a carrier that is paying for the claimant's indemnity and medical treatment. It's already been established, it's probably a few years old, and Section 44 applies at the time of permanency. So therefore, this turns into a claim where there are carriers litigating against other carriers. The claimant is no longer part of this litigation. So essentially, the occupational disease was already established and the date of disablement was already established also. So that becomes essentially the date of accident. We will talk more about what the board considers to be an appropriate date of disablement at a later morning coffee session. However, for today's purposes, we are just making a distinction between the date of disablement and the date of contracture, which is a date that falls under Section 44. The date of contracture is assuming the claimant had a long history of employment with the same or similar distinctive feature that they had that resulted in the occupational disease. So they had the same job duties essentially, and they've just worked for many different employers over the course of their career. So now the employer and carrier that were on risk and for which the case is established with, they can then bring on notice the prior employers and carriers that employed the claimant in the prior courses of employment. So therefore, they are able to apportion their share of liability based on when and how long the claimant worked for prior employers. And this is where the date of contracture comes in, because they can only go as far back as that date of contracture. And the date of contracture requires medical evidence that shows that the claimant either was exhibiting symptoms of the occupational disease at a prior employer, or they were receiving treatment for the occupational disease, there was a diagnosis in the prior employer of the occupational disease, and that is where going back in time stops, is that date of contracture. So essentially all the employers and carriers in between that date of contracture and the date of disablement would then be placed on notice. However, the date of contracture is many times prematurely set by the law judge before all of the potential employers between those two dates are put on notice. And that's what we see happen many times, where a client will come to us and say, we've just been put on notice for this 3-year-old claim and we don't even know where to start. So essentially we have to look at the file and we see if the law judge set that date of contracture and decided that before all those employers and carriers were put on notice, that is an appealable issue that the third department has actually recently found that the date of contracture cannot be set without all potential employers being on notice and having the opportunity to litigate that issue. This requires the prior medical records, potential testimony of the claimant, testimony of the treating providers, not only current providers, but also the providers that are providing that medical for however many years ago when the claimant first complained of symptoms. Sometimes it might be a completely different injury. For example, if the claimant contracted or I shouldn't use the word contracted, but if the claimant did end up with an occupational disease that did result in this claim, then the date of contracture, the medical evidence that is relied upon for a potential date of contracture, has to be consistent with the occupational disease. It can't be an injury unrelated that the claimant fell and hurt his wrist, and then later is claiming carpal tunnel syndrome as a result of repetitive use. So that's just one example of what is a factor that can be litigated. And it's just a principle that without all parties and employers and carriers being on notice and without the opportunity to litigate that issue, get their own potential IME, get an opinion on apportionment, the date of contracture cannot be set. So if you do receive a notice that you are being placed on notice for a claim that is a few years old, that's already been established, there's already a carrier who's been paying the claimant and paying for the medical treatment, and you're placed on notice based on Section 44, then we recommend reviewing the file to make sure that nothing was done that shouldn't have been done without you being on notice. So feel free to reach out to us. There are many more details that can go into Section 44, but for the purpose of the Daily Grind, we're going to keep it short today. So feel free to reach out to one of us if you have any questions. Thank you. Have a great day.